Cousin Luigi's legal team filed a 118-page motion over the weekend asking the court either to dismiss the indictment or to strike the death penalty notice. Now, in this massive filing, we get, oh, I love it, classic Karen A. It is the perfect blend of smarts, sass, and a little bit of shade. I'm not sure how I could possibly give this filing the time that it deserves in a 3 to 5 minute video, but we can hit the highlights. She makes 6 main points in the filing. Now, the first argument is that Luigi's due process rights were violated by what is essentially a media circus that was orchestrated by none other than death penalty Oprah herself, Pam Bondi. You get the death penalty and you get the death penalty. Of course, we all remember when she announced via a press release and then went on Instagram and then went on TV to describe the case and, of course, make it all about her. Now, early on, the NYPD also leaked critical case information and then choreographed this really elaborate and dramatic perp walk with the Mayor Adams, who, by the way, Karen A. took time to point out was maybe the only unarmed person there at the perp walk. Because why? Because he himself was under federal indictment at the time. Now, the motion says that talking publicly, Pam Bondi's actions of going out in public and talking about a live grand jury investigation and the specific aggravators, the aggravating factors, violated court rules, violated local rules, and that staged, very dramatic perp walk is unconstitutional and it inflames jurors. Now, the defense argues that all of this media prosecution, this publicity circus poisoned the well and violates Luigi's rights to due process. Now, the second argument that Karen A. makes goes straight at the indictment itself. When the grand jury voted to indict the case, the defense actually had a pending request that grand jurors be screened to determine whether they had been improperly exposed to old Pam Bondi's shenanigans. Now, of course, that wasn't done, and the motion argues that courts can dismiss indictments for prejudice to the grand jury process, and publicly outlining the exact aggravators to find and then securing those same findings is a showing of actual prejudice. So Karen A.'s ask here is to dismiss the indictment or at least strike the death-eligible special findings. Third, Karen A. points out that federal law and the DOJ's own protocols require that prosecutors consider mitigation information, things like mental health, a person's history and characteristics, their circumstances, before they make a decision to authorize a case to pursue death. Now here, Karen A. says that they asked for time to outline and present that type of mitigation information, and they were told no. And then the DOJ went out and publicly tied this case to a restore the death penalty MAGA agenda. The fourth point that Karen A. argues is that because Cousin Luigi faces a death-qualified jury, in other words, his case will be heard by jurors who say that they can impose death, meaning nobody who is philosophically, religiously, or otherwise opposed to the death penalty is going to be allowed to sit on his jury. Her motion argues that death qualification in and of itself makes juries more conviction prone and less receptive to defense evidence, meaning if you're willing to vote to impose the death penalty, that makes you more prone to vote for a conviction in the first place. In making her fifth point, Karen A. really kind of zooms out to attack the death penalty more broadly. She points out that even after decades of guided discretion in death penalty cases, outcomes, meaning who does and doesn't get the death penalty, remain inconsistent. And they are largely geographically dependent, prosecutor dependent, and not reliably limited to what is the worst of the worst in society. And she argues that it's this arbitrariness that violates the Fifth and Eighth Amendments. And it is especially stark here in Luigi's case, given how much this case was publicized and how it was charged in the first place. Now, for her last major point, she attacks the structure of the Federal Death Penalty Act itself. She argues that any fact that increases the maximum punishment in a case, like a statutory aggravator, acts as an element of the offense and should therefore, be presented to the grand jury. Now, the defense argues that because Congress never enacted complete constitutionally sufficient procedures for how federal capital cases pick and present and weigh aggravating factors and mitigating factors, that the DOJ cannot fill these legislative gaps with internal protocols. She says that this is a separation of powers issue and argues that special findings in the indictment do not cure this deficit or this defect. Now, she is asking the judge to either, again, dismiss the indictment entirely or to strike the notice of intent to seek death. And so this motion puts this entire Department of Justice and administration on blast for playing with a man's life and using this case as the main event or the center theme in this political theater. But it also challenges the constitutionality of the death penalty more broadly. There is a quote in this motion that says, "When the law punishes by death, it risks its own sudden descent into brutality, transgressing the constitutional commitment to decency and restraint." Decency and restraint. These are two things that I'm not sure we've seen much of in this prosecution at all. What are your thoughts?